Mr. Papp, are you able to hear me okay?
Yeah, can you hear me?
I can, yes, thank you.
Can I ask you a couple questions before we get this started?
Yep, let me just call your case real quick and then certainly do that.
Thank you.
We're on the record now in People versus Carl Papp. This is file number 256857. The record should reflect Mr. Papp is appearing today by video from Department of Corrections. If I could have counsel put your appearances on.
Good morning, Your Honor. For the record, Michael on behalf of the people.
Thank you, Your Honor. Richard Truesbury on behalf of the Papp.
Okay, thank you. So we're here for a sentencing issue that the court was made aware of by Department of Corrections. But before we get to that, Mr. Papp, you indicated there was something you wanted to say.
Yeah, I was just curious, a couple questions if you could answer for me, because I've been trying to get this answered this year long, but this is actually over a year this has been going on. Truce is yet to give me a very definitive answer. The other, the district court kind of said something, but I want to make sure, is a preliminary and evidentiary hearing the same thing?
No, I mean, they are sort of. A preliminary hearing is an evidentiary hearing, but there's all kinds of evidentiary type hearings. Preliminary hearing is a type of evidentiary hearing.
All right, guys. What you're about to witness isn't just another courtroom hearing. This is the moment one man realized his entire future was hanging by a thread. As the video connection came alive, every voice inside that courtroom suddenly carried weight. On one side stood the justice system, cold, calculated, and unforgiving. And on the other side, a man sitting behind prison walls, desperate for answers. His name was Carl Papp, and today wasn't supposed to change everything. But within seconds, the atmosphere shifted into something nobody expected. Because before the judge could even begin, Carl had something powerful to say. And what came next instantly changed the direction of this entire hearing.
What about is it the same thing as a probable cause conference?
You know, now we're getting into the area where I'm not just defining things. I'm giving you advice.
Because the only reason, I don't mean to cut you off, John, the only reason I'm asking is because I never had a proper cause, and I've told Richard this from the get-go. I never had a proper cause. I had an evidentiary hearing. I never had a proper cause. They scheduled it before he was my attorney, but I never went to it, which I kept telling him there's a violation of my due process. But the second thing is, I just got back from the law library before I had this meeting, so I wanted to make sure I don't sound stupid when I'm talking to you. That I'm just curious, and my appellate attorney told me to ask, how is it that they retain a warrant when myself and the so-called victim said this never happened, even testified in front of the district court, I didn't do this, and yet they still went and got a warrant off of a third-party hearsay, which in the Michigan court law states you cannot grant or get a warrant off of hearsay. They have to have proper, like, identifying evidence, in which the victim saying, I did this, which we had an affidavit signed. I don't know if Richard ever turned it into the courts, where Lauren said, I never did this. And then my last thing is, I was never told about a tether until like a month ago from the Department of Corrections. Because I would have never accepted this plea. I would have made sure that they took.
Carl didn't waste a single second. He came prepared. For over a year, he claimed nobody had given him real answers. No straight explanations. No clear truth. Only silence and confusion. So now, face to face with the judge, he decided this was his moment. He began questioning everything. Hearings, evidence, warrants, and legal procedures. But these weren't ordinary questions. These were accusations wrapped in frustration. Every word he spoke carried anger, pain, and years of bottled-up doubt. And slowly, everyone in that courtroom realized this wasn't routine anymore. This had just become deeply personal.
Put that off there, because that hinders my job, because a person might be like, hey, why you have that? I'm not hiring you. Because as you probably noted in my PSI, I run my own business, and I'm going to continue to do that when I get out. But if a person sees like this thing, they're like, whoa, oh, you're an alcoholic, maybe because they maybe think it's alcoholic monitor system or something. They're going to assume that I'm a problem and not want to hire me within it before it hinders my livelihood to support me and my family.
Okay.
Because I was
Alright.
never told this legit, but this whole time, no one ever told me if that's a possibility you could get this. So I'm asking the courts if they would, as the thing I got from the MDOC is to amend it where it is, because that was never brought to me, which I feel that should have been something Richard due diligence, like, hey, you know, by accepting this is also a possibility they might not make you, but they can make you. He's never informed me of that in any way, shape, or form through this whole process.
Okay.
This is pretty much accept this plea. This is the best thing you're going to get. If pretty much not, I'm going to spend the rest of my life here. I was like, well, I want to be out one day to see my son.
Okay,
But that was never
so
a part of it. Go ahead.
just let me know when you're done, because every
I'm
time
done.
I start
Sorry, I'm
talking, you start talking again. So I want you to say whatever you want to say, but just let me know once you're done so that I can answer your
I'm done.
questions.
Go ahead.
Then Carl dropped a statement that stunned everyone listening. He claimed the so-called victim had already said, "This never happened. Not once, but publicly, under oath." So how? Carl asked. Did authorities still move forward against him? How could a warrant survive if the story itself had collapsed? His voice grew sharper, louder, more aggressive with every sentence. He wasn't just questioning evidence anymore. He was challenging the system itself, and suddenly, the courtroom felt less like a hearing and more like a battlefield, because Carl wasn't finished, not even close.
Your Honor.
Okay. All right, so the things you raised about the probable cause conference, the warrant, those are both issues that you can raise on appeal. That's not something that's before me to make a decision on today. But those are grounds that your appellate attorney, I'm assuming, you know, you guys will talk about that, and those are things that can be raised on appeal. With regard to the lifetime electronic monitoring, they're two separate issues that we're raising here on that today. You're raising the argument that you weren't aware that that was something that was going to be a consequence of your sentence. That argument also is something for appeal, to tell the Court of Appeals, you should vacate my plea because I wasn't properly advised of this consequence. And the Court of Appeals will decide that. So that is also an issue for appeal. Why I set this hearing is by statute, based on your conviction, I have to impose that. And that was something as an oversight or a clerical error that the court failed to do at sentencing. But the fact that I'm required by statute to impose it is a different issue than whether you were properly advised of the consequence of that, and that you might have not entered your plea if you had known about that.
Then came the bombshell nobody saw coming. Carl revealed he had only recently discovered something terrifying: lifetime electronic monitoring, a punishment he says nobody ever warned him about. Not his attorney, not the court, not a single official. And for Carl, this wasn't just paperwork. This was his business, his reputation, his family's future. He explained how one device could destroy opportunities before he even walked free. And as he spoke, you could hear pure betrayal in his voice. Because if he had known earlier, he says he never would have accepted the deal.
That's an appellate issue. Do you see the difference between those two things?
Yes, Your Honor. So my next question is, what happens so if I move out of Michigan, because like Tennessee, where I'm thinking about moving to, doesn't require me to do that? Because this is, from understand, this is just a Michigan law. It's not a countrywide law. It's a Michigan state law. So if I move out of Michigan, technically that does not abide to me, if I'm not mistaken, right?
I do not know. That's something that the parole board would address with you when you're released on parole.
And then my next thing was, because I know this is part of your court, from what it looks like, I'm about to beat my gun charges. It looks very good on that right now. would I get re-scored? Not just my time back for that about year, which you already agreed to I would, but would I get re-scored because after doing my guidelines, it drops it down like another 2 years on top of that.
Yeah, again, that would be an issue for your appellate attorneys to advise you on. That's, I have no idea what effect it might or might not have. And sitting here today, there's no way for me to know that.
All right.
But that's something that your appellate attorneys would give you legal advice on, the effect of having any conviction vacated, what that would mean for subsequent convictions.
For the first time, the judge stepped in with brutal honesty. She made one thing crystal clear. Today wasn't about emotions. It wasn't about fairness, regret, or second chances. It was about the law, and the law can be merciless. She explained that some of Carl's arguments belonged in appeals court. Other issues, she simply couldn't rule on today. Carl listened carefully, but his frustration never disappeared, because deep down, he knew the answers he wanted might never come here. And still, he pushed forward.
They told me it'd be up to you because it technically, as like you already agreed, it'd go back. If I do beat the gun charges, I'm going back in front of you to get resentenced on this very case to give me my year back. And then on top of that, if I'm just asking you for the record, would you allow me to get re-scored on top of that then? Because by being because they told me if you take off my 2 gun charges in the 4th degree habitual, it's going to drop my time down. Even if you, again, like how you did max me out to touch my max guidelines, it's going to knock it down another 2 to 2.5 years.
Yeah,
which
so
therefore
that very well may end up back in this court if all of that happens. And if it does, then I'll have briefing from your attorney and from the prosecutor. I'll have a report from the Department of Corrections. And you're right. I mean, ultimately, I might have to make a decision on that. But sitting here today without any of that information and without knowing whether or not that's even going to happen, I can't give you an idea of what I might or might not do a year from now, having all of that information that now I don't have any of that. So I can't tell you what I might or might not do or what the law may or may not allow. So.
Thank you. I just wanted to get some stuff for the record. So when my appellate attorney gets to look at this, because we've both been just dumbfounded by how this whole thing has went down and just how things.
Then Carl brought up another explosive issue, other criminal charges he believed were about to collapse. And if those convictions disappeared, his sentence could drop dramatically, maybe months, maybe years. He asked the judge directly, would he be rescored? Would justice finally give him back stolen time? But once again, no promises came, only legal uncertainty, paperwork, and future possibilities. And Carl's fight for freedom suddenly became even more complicated.
It legit happened, especially when the victim says, this never happened, and yet I'm forced to take a plea or get 30 years.
Well, I mean, you got her pregnant, so something happened.
But she already did. But even then, we asked, not in your courtroom, in district court, how Hubbard went about this, because they didn't tell you, there's been 3 tests, and which is weird, 2 of them came back not mine. One of them all of a sudden did on the very last one that Hubbard brought from Newberry down to wherever the state lab is, which is kind of weird in itself.
All right.
But
well,
it is what it is.
we're not going to relitigate your case here this morning. That's something that you can address all of those things on appeal. What we're here for this morning is, again, the error by the court in not imposing lifetime electronic monitoring at the time of sentencing, which the court was required to do. I did review the transcript from the sentencing hearing, and the court did not articulate that for the record. Mr. Rolla, on behalf of the people, you take any position on this?
Pursuant to the holdings in People versus King, that's Michigan Court of Appeals 297, Michigan 465, 824 Northwest 2nd, 258. It's a 2012 case, and People versus Comer by Michigan Supreme Court 5.
Then the hearing took an emotional turn. Carl started talking about evidence, DNA, conflicting tests, shocking inconsistencies. He claimed multiple results had told completely different stories, and according to him, nothing about this case made sense anymore. But before he could go deeper, the judge cut him off instantly. This courtroom, she said, would not retry the case today. The past would stay in the past, at least for now. And just like that, Carl's biggest arguments were silenced, but the final decision was still coming.
100-278, 901 Northwest 2nd, 553, a 2017 case. They specifically affirm what the Department of Corrections indicated, that for this particular offense, it is mandatory lifetime sentence.
Mr. Trush.
Your Honor, to the extent that Mr. Papp has not already preserved his objection to it by his statements, for his benefit, I would indicate he does object to it. Obviously, he's raised an objection on the basis of not being aware of that as a potential consequence. Additionally, when I communicated with him prior to this hearing, he had raised an objection to me based on it. But effectively, I touched on this when he spoke, but I don't think he articulated it the same way, being a limitation on his ability to basically travel between states. So again, to the extent that he hasn't already preserved those with his statements, I would specifically object on those bases.
Okay, so those objections are all preserved for the record. From my standpoint, based on the conviction in and of itself, the statute does require the court to impose lifetime electronic monitoring. So subject to the objections and appeals, the court will impose that at this time. So we'll have an amended judgment of sentence that will reflect that. Mr. Rolla, is there anything further today?
Not in this case. Thank you, Judge.
Mr. Trush.
No, thank you, Your Honor.
Mr. Papp, we're going to go ahead and disconnect at this time. Thank you.
All right, thank you.
Then the prosecutors stepped in with cold legal authority. Case law, statutes, precedents. Every document pointed in one direction. According to Michigan law, lifetime monitoring wasn't optional. It was mandatory, permanent, unavoidable. Carl's objections were officially preserved, but the ruling stood. The amended sentence would move forward immediately. No celebration, no victory, no last-minute miracle. Just one final order, and a man forced to live with it forever. And with that, the screen went dark.